Welcome. Today we're going to be taking a quick look at a topic that I've covered in a previous video. I'll get to that in just a second. I'm going to be sharing a little bit of an update because there was a pretty significant change from a recent Supreme Court ruling that I just wanted to share an update because I had made a video on it. If you have any questions, if there's anything that comes to mind that you're unclear about, I do want to preface this by saying that I'm not a lawyer. Nothing that I'm saying is in any way legal advice, legal recommendations, etc. It's just my personal perspective on the topic at hand, and just wanted to kind of share an update because it's something, as I said, I made a video on it in the past. What we're going to be looking at is the evolving precedent of Section 230, the way that impacts internet communications, the way that it impacts internet platform liability, the way that interacts with user-generated content. So first, what actually is Section 230? Right over here we have an article from The Verge, and this is, I believe, was last updated in 2020, so some of it is going to be relatively out of date, but we'll just use this article to review the basic foundation of Section 230. Looking at this first paragraph right over here, we can see that Section 230 of the Communications Decency Act was passed in 1996. And what it does is it created a distinction between the publisher and the host of content online. So for example, if a website, let's say a social media website, is hosting user-generated content online, then Section 230 created a liability carve-out by saying that the platform could not be held liable for the user-generated content. Now, over time, that's evolved, as you can see at the end of this paragraph here, where it says, with exceptions for copyright violations, sex work-related material, and violations of federal criminal law. Now, we're actually going to take a look specifically at that latter part, the sex work part, as well as the federal criminal law part, because that was a significant change that happened in 2018. So right over here, you can see this article from Politico magazine, the sex trafficking case, testing the limits of the First Amendment. So this was from 2018. I'm not going to go ahead and scroll down through the whole article. You can do that yourself if you wanted to. However, the basic premise of this is that in 2018, there was a website called Backpage. Backpage was a website where there was a lot of sex work, human trafficking, underage sex work, underage human trafficking was happening through the personal section of their website. And up until 2018, this had happened on many websites online, and up until 2018, a platform had never been held liable for the user-generated content. Now, this is not the platform publishing this content. This is actually random people signing up, creating an account, putting up a listing, and participating in illegal activities, and using the platform as a communications vehicle for those activities. However, in 2018, Donald Trump signed a law that created a FOSTA SESTA carve-out for Section 230, criminal liability. Basically, what this meant was that if somebody was engaging in sex trafficking, underage sex trafficking, etc., then the platform would be able to be held criminally liable for the actions of its users. This was the first time, and shortly after Backpage and its owners, its founders, were actually criminally prosecuted for some of the human trafficking that had been happening on their platform. It's a case, I haven't looked too closely into it. I think there was a mistrial in it in 2021. I'd have to look into that a little bit more. Don't quote me on anything related to how the case has evolved. But in terms of the first actual stage of it, before appeal, it was ruled that the platform and the company that owns the platform was held criminally liable for the criminal behavior of its users and the user-generated content. This is the first time in the history of the internet that a platform had ever been held criminally liable for user-generated content. And this is a really, really key theme that we need to dig into. Again, it is the first time that a platform, whether it's a social media platform or a listing platform, etc., had ever been held criminally liable for the user-generated content. Now, we see this evolving, and I actually made a video on this. The video is called Donald Trump Signed the Law That Got Him Banned from Social Media. You could see it on my channel right here if you want to. In that video, I go over how, because that was the first time that a platform had ever been held criminally liable for user-generated content, what ended up happening was we saw an aggressive ramp up in moderation by platforms because it was very ambiguous as to what exactly was the status of what would be criminally liable. By the broadest definition, it was any federal crime. We saw this with stuff like the 2020 election, where after the election, there was a lot of conversations around the nature of the election and what happened around the election, and the social media platforms drew very hard policy lines for themselves in terms of what they allowed and didn't allow on their platforms, because they didn't want to be responsible for the criminal behaviors of their users in many of these instances. And so, since Trump signed this law in 2018 that created this FOSTA SESTA, the sex work carve-out, it was the first time that a platform had been criminally liable for user-generated content. We saw moderation ramp up and ramp up and ramp up. It's eased back a little bit recently. However, there's really never been any next step of precedent established. So as of right now, we have this very broad scope. Up until a few weeks ago, we've had this very broad scope where the basic understanding it is that based upon the 2018 FOSTA SESTA carve-out, that could in theory be argued in court that any criminal behavior by users, a platform could be held liable if they were not shown to be making a reasonable effort to moderate the platform. That is until a few weeks ago. What we have in front of us here is a brief for a ruling from the Supreme Court called Taamneh versus Twitter. I'm actually going to reference Wikipedia for us to actually digest it a little bit better. We're not going to go through the brief word by word. The basic premise of the case was that there was a terrorist attack that occurred, and the individual who committed the terrorist attack had been radicalized through social media. In this case, it was specifically through Twitter. There's a similar case that occurred with Google, which was actually was not allowed to continue the appeal process. However, the Taamneh versus Twitter case did go up all the way to the Supreme Court, and there was a ruling on it just a few weeks ago. So in this case, and in the Google case, the basic idea was, and the thing that was happening was that the victims of the terrorist attack were suing the platforms, in this case it was Twitter, and the other one it was Google, for recommending user-generated content that led to the radicalization and then eventual terrorist actions, the terrorist attacks. And so, in theory, this could be a situation where there was a federal crime committed, there was the user-generated content, which is the radicalization content that led to the terrorist attack, and there was the platform that hosted it. So in theory, you have the perfect trifecta of a Section 230 liability based upon previous precedent. What the court found was that the allegations are insufficient to establish that these defendants aided and abetted ISIS in carrying out the relevant attack under the Anti-Terrorism Act, as there's a lack of concrete nexus between the tech companies and terrorist groups like ISIS. So that addresses the anti-terrorism section, but it's also interesting that in a situation where they could have used the Section 230 interpretation, this is international terrorist attack, is 100% falls underneath the Federal Criminal Act. And so, in theory, there could have been the interpretation to say that under Section 230, with this being user-generated content that led to criminal behavior, the platforms could be held liable. However, this last line over here, the opinion purposely did not consider the impact of Section 230. What this demonstrates is that as of right now, the scope of Section 230 precedent and Section 230 accountability and the way that platforms are being held accountable for user-generated content has narrowed because of there being this case that went to the Supreme Court. Now, this does not mean that platforms are not going to be held liable for user-generated content ever again. On my own review of it, there was the language about how that the platforms are making a responsible effort to moderate criminal behavior on their platforms. And it was shown that even though this did end up going through, they had made that effort. So there still is the moderation requirement. But what happened in 2018 was the first time that these platforms were held criminally liable. And what that did was it expanded the scope of legal risk for these companies to the extent that they had to ramp up their moderation. And now that they have had a case go all the way up to the Supreme Court, and the Supreme Court said, we are not actually going to look at this under Section 230, because even though it could fall under that interpretation of it being a federal crime with the International Terrorist Act and the platforms allowing and hosting and distributing the user-generated content, the Supreme Court chose not to. So what this does is this creates that next step in the chain of precedent. First, we had the complete immunity. Then we had the carve-outs for copyrights. Then we had the carve-out for sex work and federal crimes, which were still somewhat undefined. And now what we're seeing is that there is an increased priority on the definition of the platforms making a reasonable effort to moderate the platforms, and that they are not being held liable. Now, you can have your opinions on this, and you can potentially say that maybe there is good cause for platforms to be liable, and you could also look at it on the other side and say, from a free speech argument, the platforms maybe are not responsible. That's not a conversation that we're going to be getting into today. That's not the extent of what I'm looking to do in this video. But I just wanted to share the update, because what we are seeing now is the next step in precedent in the world of Section 230, in the world of internet communications, in the world of platform liability for user-generated content. And what we're seeing now is in a case that very easily could have been interpreted in a way that held the platforms criminally accountable for a truly heinous act, but because they were demonstrated to not have directly aided and abetted, and they were demonstrated to have made reasonable effort at moderating criminal content, this was therefore not litigated underneath Section 230, which this is not something that comes up every single day or every single week in the courts. This is not something that has had really much clarity since the 2018 Backpage case and the executive order that Trump signed creating that FOSTA SESTA carve-out. So while I wouldn't expect moderation to end online, we are likely going to see a little bit of a loosening in terms of the extent of moderation. In fact, just the other week we saw the Supreme Court ruling was, I think, May 23rd, and I saw an article just a week and a half ago, and as of recording, I believe today is June 9th, I saw an article about a week and a half ago about how YouTube is actually going to be ending their policy of limiting and moderating election 2020 denialism, which is a direct consequence, in my opinion, at least, and is one of the reasons I wanted to make this video, because when I saw those two pair up, this Supreme Court ruling about how this did not fall under Section 230, and then a week later, a significant legal shift in the direction of how a platform is moderating content that could potentially be questionable in its nature. To me, that's very interesting. It shows that the legal analysis and the legal risk is somewhat reduced, and I would expect us to see, for good or for bad, a relative loosening on the moderation that really ramped up in 2018 that led to Trump getting banned on social media because so many platforms were concerned about the criminal liability that him and his followers were putting them underneath. Even though it was because of the law that Trump signed himself, which is a funny bit of irony. And as I said, I cover that in the other video in more depth if you're interested. But I just thought this was interesting. It's a story that I've been following for a long time. I think it's something that most people maybe adjacently know a little bit about, but it's something that I thought could be helpful. That's an update. I hope you're having a wonderful day. As always, like, comment, subscribe. If you have any questions, I'll do my best to answer them in the comments. I'm not a lawyer, so there's a limit to how much I can answer. But I hope that you have a wonderful day. Share this with a friend if you think it's helpful, and I'll talk to you later. Peace.